So, it's yet another big day here in American government. We're actually in the home stretch here, already almost finished with the course. So today, we're going to talk about civil liberties. As a side note, there are a number of court cases we're going to discuss in this lecture, and you should make sure you know the capsule summaries I give you for all of them, because they're good questions on an exam. That applies to the last lecture as well. So, without further ado, let's go ahead and get started. So, we talked about this a little bit last time, but one of the big goals of civil liberties is to offer protection from government, specifically to rein in the possibility of tyranny of the majority. And going back to the early lectures of this class, the Bill of Rights was what the Founding Fathers used to prevent the majority from taking too much power from minorities, and what they created to prevent the government from gaining too much power. Specifically, it was designed to limit the capacity of government to impose conformity costs on those individuals and minorities whose views differ from those of the majority. As a reminder, when we talk about minorities in this context, we don't mean ethnic minorities. We mean any group that is subject to a powerful majority and basically can't get favorable policy through pure democracy. This can be ethnic minorities, gender minorities, sexual identity minorities, etc., or it can just mean any group with a minority opinion that the majority disagrees with. So, returning to the discussion, the Constitution in 1787 did not seriously address civil liberties. The framers originally believed that a Bill of Rights was unnecessary and said so in Federalist No. 84. Alexander Hamilton wrote, "I go further and affirm that Bills of Rights, in the sense and to the extent in which they are contended for, are not only unnecessary in the proposed Constitution, but would even be dangerous. They would contain various exceptions to powers not granted, and, on this very account, would afford a colorable pretext to claim more than were granted. For why declare that things shall not be done which there is no power to do? Why, for instance, should it be said that the liberty of the press shall not be restrained, when no power is given by which restrictions may be imposed? I will not contend that such provision would confer a regulating power, but it is evident that it would furnish, to men disposed to usurp, a plausible pretense for claiming that power." They might urge with a semblance of reason that the Constitution ought not to be charged with the absurdity of providing against the abuse of an authority which was not given, and that the provision against restraining the liberty of the press afforded a clear implication that a power to prescribe proper regulations concerning it was intended to be vested in the national government. This may serve as a specimen of the numerous handles which would be given to the doctrine of constructive powers by the indulgence of an injudicious zeal for Bills of Rights. That was a pretty long-winded quote, but basically, his argument here is that enumerating certain rights implies that the government could take those rights away in the first place, and the fact that we're listing them means we're saying that they can't take these specific rights away. This was clearly not true according to Hamilton. Bills of Rights were written to limit the divine authority of kings, and we had no such royalty here, nor do we have the idea that the president should have unlimited power. He went on to say that the Constitution itself is a Bill of Rights, limiting the powers of government to certain explicit things, and that a Bill of Rights would be redundant. Anti-Federalists believed differently, and insisted on an explicit listing of people's civil rights. Spoiler alert, they won, and a Bill of Rights was added as the first 10 amendments to our Constitution.